Welcome to From Separation to Settlement, a family law podcast.
Hello and welcome to From Separation to Settlement, a podcast about navigating the legal and emotional journey through family law. I am your host, Kevin Rosenquist, and as always, I'm joined by Jeffrey Hale, litigation partner at Kroener Hale Law Firm. Jeff has dedicated his career to guiding families through divorce, custody, and other complex legal challenges with compassion and clear, honest advice. Jeffrey, so good to see you again. Thanks for being here.
Kevin, it's great to be here. Thank you.
So we're going to talk about, dividing assets, what's marital and what's not. This is definitely something that I think people get a little confused about, especially as far as timing of when you bought things, when you buy things. So this is a great topic to go over. Let's start with the basics. What is the difference between marital property and separate property in Ohio?
So in Ohio, the difference is going to be you look at the date of the marriage and whatever the date of separation may be, and anything acquired, purchased, any debts created, any assets gained from the date of marriage to the date of separation is going to all be considered marital property as a starting point. Now, there is a lot of caveats and offshoots, and it begins with understanding that pre-marital or separate property is going to be anything that you came into the marriage with prior to that date of marriage, but then also it can bleed into the marriage if you have an asset that's separate property, you sell it, that money is still separate property, and then during your marriage, you purchase something with that money. If you can trace it, that will maintain its separate nature.
Oh, wow.
And will still be only yours.
Wow. That could be difficult to trace, right?
It can be. I mean, if it's hard. I would say it's difficult to trace when people aren't planning on divorcing or think that they have to always think ahead and keep it separate. Now, other separate property is going to be things like inheritance. So inheritance or direct gifts to one person as opposed to the family or to these two people as a married couple, that can also be considered separate property. Inheritance will always be considered separate property, obviously, because the will would mention one person and not both of them. So that would maintain its separate property.
What about a home? If someone owns a home before they get married, how does that get treated in a divorce process?
So it would start out if one individual owns the home before they get married, then that it's going to be considered a separate asset. Now, where it gets a little muddier is when there's a mortgage on that home. So if the home is owned outright and it's free and clear, then it's separate property. It belongs to whoever owned it prior to the marriage. Now, if there's a mortgage on the home and it crosses into the marriage and then they get married and because as soon as you're married, all of your income becomes marital income. So then they're paying that mortgage on that separate property with marital income. So then the argument becomes it's still separate asset, the house, but you've gained value by paying the mortgage down with marital money. So that mortgage pay down. So if you have $100,000 house that is paid down to $50,000, there's $50,000 worth of equity that was paid down with marital money. So now the argument becomes, we need to divide that equity because that was paid down with marital funds.
Mm-hmm. So how does that work then? If is it just then 25 grand in that situation, or does it depend on the value of the house and how much you can sell it for and all that?
So if it maintains a separate property, and this is a very broad stroke, bird's eye view of things. If it maintains its separate identity and it's only the mortgage that was paid down, then your real argument is only going to be for that pay down on the mortgage to divide that equally. Now, you have a separate asset and you come into the marriage, we'll just use the house for this example, and you gut the kitchen and do a new chef's kitchen. Well, now that chef's kitchen was put in with marital money. It was paid for by marital money. And yeah, it's still your separate house, but now its value has increased because you have this big fancy new kitchen, or you've done a big new bathroom, or you've finished the basement. So now you have, if this is one of those instances, then you have to have someone come in and say, well, the house was worth this much as it was, and this new, $100,000 addition that you've added on has increased its value this much. Now there's an argument for you're entitled to half of that increase.
Right. Yeah, I mean, that makes sense. You put in the money or maybe the sweat equity or whatever, and you should get more than just that 25 grand in that scenario.
Yeah, and that's where a lot of this comes in, and it's never just sometimes it's a very straight-laced thing, easy to follow. Other times there's a lot of curves in that road because of mortgage pay down, because of additions that they've added, and those additions increased its value, and that value was paid by marital money, which then became a joint increase. So there's a lot. Sometimes there can be a lot to go in and flesh out and figure out where it's at.
Other than homes, what other assets do you find can be tricky, or maybe more complicated to divide?
Retirement assets can be, if there's, you have a premarital retirement asset, you get into the marriage, and now you have two incomes. So during the marriage, you start dumping a lot more money into this, what used to be a separate asset. So you have to now feather out, okay, its value was this much. And now, since coming into the marriage, it's still their retirement account. It's still, that portion of it's still separate, but now they're going to have to divide the part that has grown during the marriage. Now, the exact opposite of that is you have a retirement account, and nothing is contributed during the marriage, but it's grown just by the sake of the stock market. So everything's went up, it's grown. That is still separate property. Nothing marital has touched that account. It's just grown by the very nature of what it is. And that's still a separate asset, with all of that value going to the person that owned it pre-married.
Mhm. What if marital money was put into it and it grew? Is that taken into account, like the actual the profit from it?
Yes, that's when you start bringing in experts that can,
Right.
basically, and this is a very rough, because I'm horrible at math, but
We're in
basically,
a club.
the very rough of this is, you have to go month by month, and they have to see what the stock market did, that day, that month, whatever it was, and they have to separate what it would have done without the marital addition, because that would be separate, and what it did do because of the extra money in when the marital money was added in, that extra money compounded on top of it. So instead of $100,000, you had $150,000 compounding that interest. So
Mhm.
you get into some very, very deep math to separate that out.
Yeah, I feel like that's something that a lot of people wouldn't know going into a divorce, that's how that works. So are there other things? I'm sure there's lots of them, but what are some of the top things that you realize people don't understand when it comes to dividing assets in a divorce?
I guess the hardest thing, well, it's not the hardest thing, but I guess the thing that, to me, in having done this, and probably for a lot of attorneys after you've done it so long, is when people come into your office and they don't they don't understand that if they worked outside of the home, and they had an individual that was basically staying at home taking care of the home, I very frequently I hear, well, that was my money. I paid for it all. I'm the one that worked, and I paid for all that stuff. That's mine. Well, from the date you get married until the date the court decides this is your date of separation, when you become an individual again, it doesn't matter if the individual who stayed home did not bring a single penny into that home. they aren't basically are considered to have earned half of everything you earned.
Mm-hmm.
And it's sometimes it's hard to explain to people, I realize that you're the only one that worked outside of the home, but that's a marital asset because this individual worked and maintained the home, which allowed you to go outside of the home to earn money from someplace else to bring back into the home as a marital asset.
Mm-hmm.
So that can be a pretty tough situation to explain. And then it's always hard to explain to somebody why they're about to lose half of their retirement. That that's always a very tough and not not a very good conversation to have.
Can prenuptial agreements factor in as far as that goes? Can they if you have if let's say somebody has, a lot of money and they're getting married to somebody who maybe doesn't have a lot of money, a lot of assets. When you do a prenuptial agreement, can you state whether how much of can you change how that marital property is looked at, or is that no matter what the law says that's a 50-50 split?
No, we have helped several clients with prenuptial agreements, and those can absolutely change the landscape during a divorce
Okay.
because you're now Ohio is very strict with what they require when it comes to a prenuptial agreement that is going to ultimately be considered enforceable. I mean, it has to be full disclosure. I mean, you have to lay out all the assets, all the debts that each individual owns, what that estimated value is, because they're very big on you have to make an informed decision. And if that disclosure is missing or it's severely lacking, then the court can choose to throw out part of it. They can throw out the whole thing. So you got to hit the marks, and you need an attorney that understands what's required in a prenuptial agreement in the state of Ohio.
I've asked people this before just out of curiosity. Do you feel everyone should get a prenuptial agreement?
I mean, it depends because here's the thing about it depends, I guess, on your. I always feel like a prenuptial agreement is you're kind of foreshadowing what you're expecting to happen, which
No, it's certainly a tough conversation, right?
yeah. So, but then it's the thing is that if you have separate property and you maintain it as separate property and you're diligent in it, then you're still going to get to keep a lot of your separate stuff.
Mhm.
Now, ideally, the prenup helps for individuals that plan on, not being so diligent about it. But even then, there's still going to be some required tracing, and a lot of prenups are challenged because ultimately the court can look at a prenup and just say this is just unconscionable. So we're not going to allow this to stand this way.
Oh, really? Okay, that's interesting.
So they can make that decision if they find it to be just severely unfair. Because remembering that domestic court is a court of equity, which means they want to do what they think is absolutely the right thing to do. I mean, obviously there's rules, there's laws that have to be enforced, there's things that are in place, but ultimately it's a court of equity. So if they look at a prenup and it's very lopsided, it is there's no way. And then they also look at the timing of the prenup. You don't if you have someone and I in his example, my office has challenged prenups that were signed 2 days before the wedding.
Mhm.
That prenup gets thrown out because they didn't have any time to consider it. They had no time to go have it reviewed by an attorney and to sit down and have a meaningful and fruitful discussion about what the terms are, make sure that they understand it. If one side is represented and the other side isn't, that's going to cause the court to squint at it and say, okay, well let's see what this is about. Because typically, if it has one side's represented and one side's not, it's usually pretty lopsided.
Right. That's interesting. Yeah, I guess I think the conventional wisdom is, oh, prenups are ironclad, but that's not the case.
No, I mean, there are some really good prenups. I have attorneys that I like very well, and they do very tough prenups. But the problem is ultimately, you know, if you don't follow the statute word for word, the court can, I mean, they don't have to throw it all out, but they can strike out pieces. And one of the ones they love striking out is the no spousal support, or I'm not gonna have to pay any portion of this house that we've built and raised together. So it's they can be very tough, but then a lot of times you'll find people will just pull them offline or get them from, some legal document service, and it's just not right. It's not set up correctly. Even if they say it's for this state or for that state, a lot of times it's still missing a lot of stuff.
Yeah, that seems to happen a lot with any contracts, whether you're trying to use AI or random websites you find. Like, you got to remember the boilerplate, and they don't always cover all the nuances.
Very true.
The
Very true.
online ones, yeah. Yeah. We talked a little bit about inheritances or gifts. Are there situations where they can become marital property?
Inheritance is, I would say yes, but and just for example, inheritance is, I mean, those are a little harder because usually, ideally those things have come a little bit later in life. It usually comes as this big lump sum, so you can easily see it hit an account, and then you can see as it goes out of the account. Now you can, and I've seen it before where the lump sum comes in and it goes into a marital account. Now you start to get into an issue where you're starting to mix assets. And so if it reaches the point where it's been so intertwined and mixed that it's, number one, it becomes very, very hard to trace. Number two, the courts can just say, you know what, this is so murky that you've intermingled this so much, it's lost its separate identity. And at that point, then the courts can find that it is a marital asset and it needs to be divided. I mean, I think inheritance is a little easier to show because it's usually a lump sum. A lot of times people won't even put that into a joint marital account. It'll go into a separate account. Now, they may use it and give money to the other party. Uh, gifts, gifts are they're usually easy if you have someone who like specifically lists a note, or it says, this is my gift to you, or it's a birthday gift or something like that. I mean, there's always these nuances straight across the board. Inheritance and gifts, you can usually show they're separate, and especially a gift, if the person's still alive, they can come in and testify that this was a gift.
Yeah. Good
Uh,
point.
the inheritance, on the other hand, obviously, the point of inheritance is they're usually no longer with that person. So that has to be kind of traced through the accounts. As long as they keep it separate, or as long as it's used to buy a very distinctive thing, like you go purchase a home, you get your inheritance, you go get a home, or you inherit the home, then those are easy to trace. When it's just money and it gets mixed into the account, that becomes a little more murky.
Yeah, that makes sense. Wow, very nuanced to say the least, dividing these assets. All right. Well, thanks for joining us today on From Separation to Settlement. If you enjoyed our conversation, please be sure to subscribe to our channel, leave us a review, share the show with someone who might need the support. Jeff is a wealth of knowledge on the subject. For more resources or to connect with Jeff and the Kroener Hale Law team, please visit KroenerLaw.com. And remember, every journey starts with one step. You don't have to take it alone. Jeff, so great to see you as always. Thanks so much for your time.
Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.